today's topic is just to kind of a reminder of some of the risk management issues that come up in the marketplace that we presently have, which we hope will sustain for many years to come. And where I'd like to start, and I'm going to also delve in a little bit into condos and TICs. Condos in particular, there's been some changes to the Davis-Sterling Act for those of you who work with condos. I'm not going to go into all the technical changes, but I'm going to give you an overview real briefly. So, yes. Oh, aim at the thing. Yeah. Hold this closer. Is that better? Great. Thanks, Weyand. So, first, the way I've approached this discussion is really sources of risk. And let me say that I completely get that in practicing real estate, we have both a marketing aspect, which is vital, and then we have this risk management component. And I appreciate that you've got a very tough job to do in a tough market in marketing, and sometimes this risk management component is tough to put the same level of attention to. And my speech on that is it's going to save you a lot of time in the long run. Because the last thing you ever want to be involved in is any kind of a claim. That will distract you. It will interfere with your marketing. It will erode or completely negate a lot of great marketing work you did with a client who may be very happy with what you did, but they're not happy now. If they're a buyer or seller, they have legal fees they have to pay to defend a claim that ultimately, I can assure you, having represented and defended brokers and agents since 1985, ultimately there's going to be some blame game going on, even if it doesn't result in a claim. So I start off with the main kind of bedrock document we have, cornerstone document we have, which is the TDS and the supplemental TDS here in San Francisco. And these are three common areas of risk that we have seen over the years. And they keep recurring, so I thought I'd bring them up again today. Blanks and explanation issues. Seems fairly self-explanatory. Everybody gets busy, and I got to tell you, one of the first things I do when I get a file is I look to see if it was a dual agency case, because judges to this day do not get dual agency. I don't care where, who, how. They don't get it. They find it very difficult to believe, because they were lawyers practicing at one point in time, that you can represent a buyer and the seller at the same time. They just don't get it. So I look for that first, and I'm not going to go into detail on dual agency issues today. I'll comment on a few things as we proceed. But blanks and explanations, and here I'm talking about literally where a seller has not fully completed the TDS. Or, and this is the more common problem, when they get to the explanation section, they leave an incoherent, an unintelligible, something that can't be understood, something that is incomplete, and more often it's incomplete explanation. Let me give you an example. The boxes are checked indicating that work was done without permits, all right, some work. And then when you get to the explanation, and then there's some other boxes checked that relate to, say, a neighborhood issue or the like. And when you get to the explanation, they may have checked 3 or 4 boxes, good news. They may have given disclosure about being aware of some issues, good news. But when they get to the explanation, they only provide an explanation for maybe 1 or 2 of the set of things that they have indicated are an issue for the property. That happens recurrently. It's going to happen. I've seen it happen for almost 25 years since Easton v. Strasburger, resulted in transfer disclosure statements to the state legislature. Just watch out for that. Your obligation as a fiduciary to your client is to point it out, bring it to their attention, suggest they fill it in. If you ever find a seller, of course, who doesn't want to fill in those kind of blanks, I suggest you talk to your manager immediately about it. That could be a major red flag that you have to deal with. Internal inconsistencies. Now, we're starting to get the tougher things to find. I know this is somewhat statement of the obvious, but internal inconsistencies are sometimes tough to spot, particularly when you have the TDS and the STDS, and you have a property inspection report, and you have the pest control report, and you may have all sorts of things that the seller has provided you. You just have to do your best. You have to look for, particularly when the seller is identifying certain matters that they are aware of that are property issues. Then cross-check what they've said in the TDS. And then also cross-check with the separate documents that come in through other sources, as I indicated, the property inspection report, but the 3R report. And this is a recurrent problem in San Francisco. You get the 3R report, and we all know from the SFAR advisory. I think a lot of companies have advisories. 3Rs are almost worthless. They are not reliable. They just are. And the best information you can give is the 3R and a strong recommendation, as it states in the SFAR advisory and in other company advisors, that the buyer would be well advised to engage a qualified contractor or architect to go down and pull the records and get the entire permit history, get it cleared out. But time and time again, we see 3R reports that have issued, but there's no completion. You've got the X's where the permits have expired, and there's nothing really reported in the TDS about that, and these permits were pulled during the ownership of the current seller. So it's something to watch out for, because here's what happens. If a claim comes in, lawyers put a microscope on every single thing you did, and they act like it's the only thing that has happened for the entire life cycle of a case, which could be 2 or 3 years. That's all they think about is the 20 or 30 days that the agents worked on a file. And so it gets heavily scrutinized. Let's go to the next slide, hopefully. Aim at the projector. Okay. This is further to the comments about the 3R report. It is real common, particularly in my experience in markets, and frankly I've seen it in up markets and down markets, but in up markets you have sellers and buyers saying, look, you're getting a big commission, what are you doing for me today, right? And they start pushing agents to undertake obligations that are not required by law. And many companies, I represent several brokerages in town, and I've done a lot of risk management over the years, and I'm very, very closely aligned with folks like Bill Jansen, Vicki Nadorf, many of you probably have heard of before, have seen speak, risk management icons really in this industry. Don't go to public reports. Don't let a seller pressure you into doing that, would be the strongest recommendation I can give. And here's why. The minute you go pull a public report at DBI, the minute you go online and start looking at permit history, the minute you go to the SF Superior Court website and start looking at cases, you have just put yourself in the shoes of, in the last example, a lawyer, in the DBI example, a contractor or an architect. Courts will hold you accountable to the standard of care of that professional. You're no longer a realtor. So there are people out there that have heard that advice over the years, and I knew a broker, had a small shop for many years, who heard it and smiled and said, you know, look, I grew up, my father was a developer, I grew up in development. If I can't go pull records, I don't know who can. And this particular individual, you know, wouldn't listen to the advice, but did a great job. Very rare. Strongly recommend you not do it, because it's not just a matter of getting things right in terms of what you see, reporting it accurately to your client. It's a matter of reporting it, as I indicated, as if you were a lawyer. For example, with the court records, the minute you go and look at, let's say there was you're selling a condo unit in a 6-unit on Haight Street that was an old theater or the like redeveloped. I'm just making this up, right? And you go look and you see there was a condo defect lawsuit, and you see all these attorneys involved, and you start looking at the very first complaint and you see what's listed there. You're going to be held accountable for every single document in that file, and you're going to have to give a report to your client as if you were a lawyer, and you're going to have to think of the extra questions that you would ask that are prompted, arguably, by giving that notice, by getting that notice. Same with DBI. The minute you start getting into the permit history, first of all, anybody who's been down to DBI or accompanied by an architect, no doubt, or a contractor, knows their records are shambles. I mean, they'll say whatever they want to say. They have archaic records. When you get past a certain point in time, and I can't fault them, everything was written by hand at one point in time, right, around the earthquake and after. They can't read the stuff. If anybody's seen old permit files you can't read most of the entries there. So to get someone to look at that file and say it's complete to begin with, that the DBI has assembled everything, that's already a chore. But to get them to give an accurate review of that is even harder. So I stress that point. Completed repairs keeps coming up. This is the seller says, oh, I don't need to disclose the roof work I did or the window I fixed because it hasn't leaked for 3 years, right? Well, it's been pretty dry around here for the last couple of years. And it's always, your obligation to recommend that that sort of thing be disclosed. And if you know about it, you need to disclose it if the seller doesn't want to. And the obvious reason is, and I got to tell you, it's like Murphy's Law. Every time something like this isn't disclosed, that's when a claim comes in. Because rains come along, the windows leak, the roof leaks, and the completed repairs just aren't sufficient. An entirely new roof, slightly different issue, but there you're going to provide the information, new roof put on. So the buyer will be advised to look into it. Yes?
How far back do you have to go back on that? Say we're selling a home in the Sunset that people have owned 50 years.
Yeah.
How far back
is reasonable? Yeah. Did everybody hear the question? How far back do you go is the question when you have repairs that have been made. I got to tell you, I have to recommend you always disclose them because my experience is those cases where they're not disclosed because nothing's happened for 20 or 30 years, those are the ones almost that pop up. Because it turns out that, just because we haven't had the type of rains that existed in a particular period of time. I know 20 or 30 years is a pretty extreme example, but generally speaking, the safest thing to do is to disclose it. In an up market, disclosing is usually not such a bad thing. Folks seem to not pay that much attention to it, and it gives them an opportunity to investigate. But again, repairs versus completely redoing the roof, two different stories. You put on a new roof, I'm less concerned about it. Settled lawsuits, this one comes up both with respect to property condition problems, but also here in town with rent control, with lawsuits that have been brought by tenants. And we have seen claims come in both categories where folks thought there was no problem because the property condition lawsuit had been settled and or the tenant claim, landlord-tenant claim had been settled. Let me tell you what the problems are with the property condition, particularly when you get into condominiums, any kind of multi-unit property, whether it's a TIC or condo. If they sued the folks who developed it or converted it for any kind of property defects, you have to ask yourself a question: how much net money did they get? Okay. So when you sue, for example, when a condominium, an HOA, sues a developer, they may get a recovery of $1 million. That sounds great. And that may correlate to the repair surveys that their experts provided, right? That's all good too. But did they spend all the money on repairs? Well, we know right away they had lawyers involved almost always. And probably most of those lawyers charge on a contingency. And a common contingency is a third of that recovery. So you got $1 million in repairs, in my example, and $660,000, rough numbers, in net dollars to spend on the repairs. Who took care of the gap? How did the gap get taken care of? Did it get taken care of? That's the big problem with a lot of settled lawsuits. The other is that the lawsuit, while it was settled, there's still an underlying problem of some sort. And this is more on the tenant side of things. We've had claims come in where a tenant has been very, very difficult on a landlord and has gone to, they've got their rights. They've gone to the rent board repeatedly. There have been claims they've filed, actually, that manifested in lawsuits. They all got resolved one way or the other. Property is sold. Landlord, seller does not provide any disclosure of that information. And guess what? This tenant surfaces again because they're a difficult tenant, and they ultimately make a claim. And when a claim is made, the landlord, new owner, finds out, geez, there's this whole record here. How come you didn't tell me? Had you told me, I might have approached this property differently. I might have asked for some money, some credit to deal with this tenant. And that one's a risk to also watch out for. Okay. All right, so this one gets a little tricky, and it's because you have, under the category of reselling properties, you have files, right? And so there are two kinds of files I've learned over doing this practicing in real estate over a number of years. There is the broker file, which is the company file that we get if there's a claim, and that is the file, if you will. But there are agent files, right? Many agents keep their own side files. And companies have different policies. Many companies say, no, you can't do that. There's only the broker file. And the broker files are maintained per Cal BRE rules. Some folks will stretch it for another year or two, but generally 3 years, 4 years. The agent files often are for marketing purposes, but they may have information in them that is disclosure information. So here's what happens for the folks who have practiced as agents in town for 15, 20 years. They may have sold the same property once, or twice or 3 times. So is there an obligation to go back and look in that agent file for all disclosures that have occurred in the past? I got to tell you, there is. There is. You have to make a full disclosure as a fiduciary to your own client. If you're representing a buyer and you know you've represented the seller of that property in the past, you have fiduciary obligation to deliver that information. The trickier part gets to the company file, because companies, you know, they live on for 10, 20, 30 years, and they may have been involved in many transactions with respect to the same property. Every company has its own practice. I can only tell you what occurred about 5 years ago with a prominent company, not this one, when the Cal BRE came in, and it was a single-family home here in San Francisco, and the Cal BRE said, company, you sold that property in the past, in the last 18 months. You had the full file from that prior sale. There was information in that file that buyer number 2 would have liked to have seen, and was indeed material, important to making a decision. It went to the issue of value or desirability. That information was not provided. It was within your control as the broker. You could have easily reached into your storage, pulled it out, provided it. And Cal BRE came down very, very hard on the supervising broker and the agent in that instance. And it also cost these folks some money, not just for lawyers dealing with the Cal BRE, which is a licensing issue, of course, which is critical, but also on the civil side. So it's a very tricky issue. The best thing I can recommend, and each company has its own practice, is just, you know, most of you know if you sold the same property before. If you have, bring it up with your manager, have a discussion, figure out how you're going to assemble the proper disclosure. Yes, Tara?
Actually, that is our policy, and you'll fill out a piece of paperwork when you take a listing, or a contract that states the property address, and your office manager or escrow coordinator will pull that file if in fact
Perfect.
Zephyr has sold that property.
Perfect. Yes?
In the case that we disclosed a property last month, I sold it under a previous broker.
I think
You don't have access to that.
you don't have access to the file, and I would be leery of getting into specific transactions. I'd suggest that be referred. I can speak hypothetically. Generally, in a hypothetical like that, where you've sold for a previous broker, unless you have agent file materials, which you should bring to the attention of your manager or to your client, there's really not much you can do. You know, you can certainly, if you have, here's the thing about disclosure. If you know something because you've sold a property repeatedly, let's say there's a property that borders some kind of, I'll make up an example, a local park, and you happen to know that local park has streams that pop up whenever it rains, just the way the water flows from this local park. That's not disclosed anywhere, but you have personal knowledge of it, and you have knowledge that those streams sometimes create a little runoff, and there's going to be a little water flowing down the street near this property and mud, and people, you know, have commented about it. It's a material fact, maybe a minor one. You know something, you have a duty to disclose it under California law. There's no rule that says it's just what you have in your file. It's what you know fundamentally. Another question.
Are we supposed to be asking our sellers, like say we weren't representing them on that purchase?
Right.
But we should be asking them for their files when they purchased it, and the things that were disclosed to them and their...
Yeah, did everybody hear the question? The question is, when you're basically taking a listing, do you ask your seller if they have disclosures from their purchase of the property? I'd say as a general rule, you start off with the TDS and the STDS. It certainly, here's the risk. If you're the fiduciary and you don't ask for a copy, you ask them, do you have a copy of your transaction file from when you purchased a property and all the disclosures in it? If you don't ask for it and there's a later claim, I can almost assure you, and I'm not taking a stand on this, I'm mostly, the vast majority of what I do is defense work, but there will be an expert witness somewhere who says that your fiduciary duty was to make that request and to make sure that those documents were reviewed and produced to the buyer. And it's going to happen if there's a claim and there's some, and I've had this case, there's an inconsistency between the TDS provided by by seller one, and when that seller, the TDS provided by seller one, and when buyer one is seller, so buyer one is now selling the TDS they provide. And I've seen it, for example, with easements. That's the last time it came up. There was an easement disclosed that was certainly in the preliminary title report, but there was an understanding that local individuals had about the scope of duties that landowners had. It was a very peculiar situation where an easement was recorded that required maintenance of private road. and people in the area knew that there was some fairly major requirements on maintenance, and it was not really reduced to writing anywhere in this particular transaction. However, seller one made comment, put the buyer one on notice. Fortunately, when buyer one sold, now seller it was the seller, they didn't make those same disclosures. Then buyer two comes along, finds out about these requirements, and of course, what do? You immediately start making complaints and saying, why don't you pay for it? Why do I have to pay for this annual maintenance fee that is set up by a bunch of neighbors? Okay? Appraisals. This one's, oh, I'm sorry, yes, sir.
So, a little unclear with agent files, is there any legal requirement if you have agent files for the length of time you have to hold on? And since most of those life cycles for properties, you sell a property 5 to 7 years later, maybe you turn around and sell it again.
Mm-hmm.
I hold on to my files for a while.
Sure.
Is that not a wise idea? And
Well,
is it also, one more question, and that is, would it be a fiduciary appropriate thing to do as a fiduciary to tell the client, you might not want to hold on to this file after 3 years, but they could show up.
Yeah, two good questions. Everybody hear that? So the first question is, how long, and I'm just going to recap, how long do you hold on to an agent file? Second is, do you give advice to your seller along the lines of, you might want to consider disposing of your file after 3 years? So let me cover the agent file first. In California, the structure, the Cal BRE structure, is that the broker sells and buys. The broker is the listing party, and agents are considered to be sub-agents of the broker. And I don't want to get into a long technical discussion, but the way BRE looks at thing is the agent file really should be in the broker file. That's Cal BRE's view of the world. Agent files, in my experience, are almost always duplicates of what's in the broker file. It's rare, in my experience, that an agent file is going to have things other than perhaps regarding marketing, which is really not going to be relevant to disclosure, that is not in the broker file. So the first answer is, as long as the broker file has everything, you could keep your file as long as you wish. Now, if you do that, you're going to have to be meeting the obligation of disclosing anything in there that has material, that constitutes material information. So that's the burden that goes along with that. I totally get, again, many companies, I can't speak for Zephyr, but many companies have a policy that there are to be no agent files, even though we all know there are. If Zephyr allows for that, I just think you want to be careful with your own agent file. I have heard risk managers within the last year make the suggestion that what you want to do ultimately with your agent file is dispose of it in something like a 5-6 year cycle, and you can always cherry pick the key things you need. I mean, you've got to ask yourself, what do I really need in my agent file? What I really need often is the marketing information. I'm not so sure something like an old appraisal report or the like, which we'll get to in a second, is what you really need in there. So you might consider just keeping the marketing information, and then it's going to make life easier. But let me underscore, if you know of a problem, just getting rid of something in your agent file doesn't change the fact you know of a problem that needs to be disclosed. The second component on sellers, I wouldn't touch that one. I think sellers should just be encouraged to, here's our problem. For example, in a tougher market, in a down market, sellers are, in my experience, a little bit more reluctant to disclose, right? All the veteran agents have seen that, experienced it. Suggesting they not keep files, for forever, I don't think that's to the benefit of the real estate professionals. I think it's going to put us at greater risk. I'd suggest we not do it. And I think there's a policy reason for it, not just a risk management one, but a policy reason. Ultimately, who lives in the property? Who is the most informed property? It's not going to be the agent, it's not going to be the buyer, it's going to be the seller. So I think putting the burden on them to make a full and complete disclosure using all the materials they have is very fair. And that's what, if you think about the way CAR in its advisories and the local association in its advisories, the direction we've gone since .com, it's to put more and more weight on the sellers. Look what's happened for the veterans since .com. Before .com, we didn't have a statewide seller advisory. After .com, we do. Why? Because the feeling was more could be done to advise folks, and I think it's been successful, by the way, of what their obligations are, both sellers and buyers. So that would be my answer to both those questions. Appraisals, just brief. Oh, yes, sir.
One of the big issues that may come up today is really a whole email trail.
Yes.
And, I mean, a buyer, a seller has an email trail, another agent has an email trail that relates to your
Yeah.
transaction.
Yeah.
How far do you go?
Yeah, yeah. Great question. And texts. Let me add texts into that one too. I think, it's the rule is always going to be that you produce everything that you have that's material. So if you have been emailing a prospective seller for 5 years to keep things hot or warm, and there's anything material in those emails, and the question that, I'm less concerned about single-family properties. I think you're going to probably remember it. It's more condos where it could be something that doesn't seem like such a big deal, but later becomes one. Examples would be a nuisance neighbor in a condo, big or small condo project. Another one would be a property condition issue that supposedly is being handled by the HOA. Bottom line is you got an obligation to produce anything that's material, and that's a problem with emails, I recognize. Unfortunately, it's the same thing with text, which is why with text I strongly recommend not using them for anything that pertains to disclosures. I would stick with using them for just setting up meetings, passing along phone numbers, basic stuff that's not going to implicate the disclosure obligation, and that's tough to do. If you're going to be using text at all in the same way as emails, I'd strongly suggest that you get, and maybe management already does, some kind of a device that's going to allow you to copy all those. The CalBRE requires it. Anything that pertains to a communication has to be saved to the broker file if it pertains to the actual transaction or the disclosures. So I would keep that in mind as well. Does that answer your question? It's a tough one on emails.
Well, I guess to go a step further.
Yeah.
What obligation, if there's something that is mentioned that
Yeah.
is disclosure oriented?
Yeah.
I presume you also need to have both sides of the transaction perhaps sign it.
It's a good idea to print. So that's a great point. Is with emails, they are electronic, and you want to make sure that they've been received by both sides. So you're absolutely right. Now, if it's an email between you and a seller, in my example, I think you just hard copy it out, and you definitely have it signed by the buyer, and you're going to forward a copy to your client. So I think that solves it. A buyer email, I'm not sure. I think buyers are going to have questions. You're going to want a hard copy to the file just to have a good record. But I'm not sure any of that would ever go back to the seller, right? Because buyers, essentially, are just going to be asking you questions as the fiduciary about whether they should buy the property or not. None of that would necessarily go back over to the seller. I think it's more on the seller side, particularly where you've kept in touch after selling them the property, that you may have emails that could be problematic. Okay? Appraisals, real briefly, why do I mention them? I'm talking about old appraisals. We're not really concerned about new appraisals. I got to tell you, old appraisals sometimes have material information that doesn't appear anywhere else. Easement example, again, I had one claimed several years ago where the appraisal report that had been provided to a buyer when they purchased the property had references to an easement that was a right of use easement that had never been enforced by local government, but it did give local government a right-of-way use over a piece of somebody's front lawn. You can only imagine the fear someone might have that government's going to take away the corner triangle of my lawn and about 25 square feet of it in order to expand a local road. So that was not disclosed by this particular buyer when they sold the property, and no one was aware of it until after a claim came in. And then midway through the claim, we finally got production of the documents, and we saw that in there, and that was very useful to us in defending an agent. So it's a tough one. Here's the problem with appraisals, and let me answer the question in a second. It's a tough one, but you can show it to your manager, and generally you can redact or black out some of the value information. That's, you can argue, is not material. It's up to your seller, because they're the ones who are usually in possession of that document. What I'm thinking of are the appraiser's comments. And folks familiar, with reviewing appraisals know those appraiser comments can be they can be very detailed. And we know the basic stuff, local schools, all that. I'm talking about really drilling down. And it just so happened this appraiser was familiar with this neighborhood, knew about this right away. In fact, it seemed like everybody who had practiced anybody who had touched real estate for 30 years, local realtors and so forth, knew about the public right-of-way issue. But this particular group of realtors, they were from a larger company, They didn't know, and hence the concern and problem.
Wouldn't the easement be on the preliminary report anyway?
This was a public right of way that was recorded on the original subdivision map, and it was in the nature of an easement. And it didn't, certainly the original subdivision map from 1926 or whatever was referenced. But I got to tell you, getting people to go pull a subdivision map and start looking to see where the private roads are, and then figuring out the private roads and where they correspond to reality, because anybody who's done any subdivision work at all knows that they lay these things out, particularly when you go back in time. And engineers lay them out, surveyors lay them out. They're accurate for the time, but it's very common for a 15 or 20 foot wide road, as depicted in a subdivision map, to narrow and ultimately be 15 feet or 17 and a half feet. Well, then what happened to that extra 2.5 feet? Well, it's on somebody's lawn, essentially. That's what happens to it. So, because roads, the law on roads is kind of interesting. Probably you all know this. The owners of the adjacent two adjacent properties, you can just kind of imagine two squares side by side with the line that is in the middle being a private road, and then expand that out about 10 feet on either side, so a 20-foot private road right down the middle. They own to the middle line, right? The road just lays on top as a right of way. That's what government's right of use is. So that's the answer to the question. I talked about agent files. I don't need to cover that anymore. Okay, so now kind of today's market. No contingency offers. Boy, you know, that one for lawyers, defense lawyers, kind of gets your blood pressure up a little bit, because, geez, you're going to do a no contingency offer. How much is the property selling for? And, you know, I've kind of gotten used to it now. When I first heard about it, that's exactly what my reaction was about 6-8 months ago. What? No contingency offer? Well, we got a playbook, and I'm sure everybody uses pretty much the same playbook, which is we do disclosures in advance of most open houses, right? Get the disclosure package to a serious buyer in advance and recommend, and I've heard of no problem, I'm sure there have been some, but I've heard of no problem in getting cooperation from the seller through the listing agent to do a pre-offer inspection. So it's a lot of work, and it takes a little bit of extra investment, but buyers seem to be willing to, and I'd encourage it because it's good risk management, to do a pre-listing inspection with a property inspector and of their choice, and everybody's got their referral source. That clears out that issue. It allows the buyer to go in with open eyes. Because the TDS is being delivered almost always in these pre-offer disclosure packages, there is no right of cancellation right under the TDS, right? That right is only there if it's delivered after the parties enter into a contract. So I mentioned marketing versus risk management. From a risk management standpoint, it is a higher risk situation. There's no way getting around it. All the folks who are on the management side have seen what happened after .com, seen what happened after this 08 thing that was the worst in my lifetime of a downturn. Buyers all of a sudden are blaming the agents for not making stronger recommendations to do more. That's just the reality, and it's human nature. You've got a big problem to fix. You're going to blame other people if you can't afford it and if you can't get an insurance company to pay for it. That's just the reality. So buyers blame the seller. The seller, usually the pattern is, tries to solve it on their own. The minute they realize it's not going to go away for peanuts, it's going to spill back over to the realtors no matter how good a job you did. That's the best advice I can give on no contingency offers if you go in without that, you're going to be going in with on the property condition side with a buyer that if they discover something is going to have some concerns. It won't happen in the upmarket. It'll happen when things level off. Post-acceptance negotiations for right to inspect with contract. I've just had this one come. I mean, we all have seen this. This is just a practical thing. What do you do? No contingent offer. Do you have a right to inspect? The answer is no. San Francisco form of contract and the CAR form of contract give you that right if there's a property inspection right. If you've waived it, you've got no right to get anyone in. So you got all sorts of things that happen. What about if you have retained an appraisal right, okay? And the bank wants to get in with somebody. Doesn't happen all the time. Usually they send an appraiser. You're not going to have any luck on that. So it's a very difficult situation to be in when you have a no contingency deal. Did you have a question?
So what you're saying is, if you have an appraisal contingency in your offer, you can have an appraiser in.
Correct.
If you've waived your appraisal contingency
Yeah.
And you've waived your loan contingency.
Yeah.
The seller may say,
No one comes in. They have a right to say.
"Seller has the right to say no."
Yeah, absolute right to say no. Now, many sellers, certainly if we get a call, we encourage the sellers to permit it because it's good risk management for sellers. I mean, the reality is, it baffles me when people stop and think about it. I think they almost always get it. They're better off being transparent. It's just the reality. You don't want to sell a property and not be transparent. It's going to come back to haunt you, almost always. So the answer is, these permutations are interesting because, just to recap, no property condition, no inspectors come in, property inspectors. Appraisal right, you can get an appraiser in. Appraisal right is waived. You're not going to get an appraisal in. You got a loan. How about the loan contingency? Can you get an appraiser in? Yeah, of course you can. The way the SFAR contract is structured, you can get the appraiser in for that. Once that's waived, and there's no appraisal condition, you're not going to get anyone in. And you got the right to do the walkthrough, the customary walkthrough at the end, which is plainly stated in the SFAR contract as merely a walkthrough. I can tell you, from my understanding, its origin was simply just to make sure things like the washer and dryer was still there and hadn't been inadvertently moved. That's about it. And to make sure there was nothing crazy that happened. But it is not a disclosure. It's not an inspection walkthrough. Yes, ma'am.
What's your recommendation when you're representing a seller and the buyers submit non-contingent offer, so no contingencies, but then after you get a contract, they say would like to have full inspection?
Yeah.
Just for informational purposes, and they haven't put anything in the contract to indicate that they want to do that. Of course, the inclination is to want to allow them, but in terms of protecting your seller,
Yeah.
you're allowing them to discover some material thing that maybe no one else has discovered before.
Yeah, it's a tough one. Did everybody hear the question? What do you do after in a non-contingent when the buyer says, I want to inspect? I mean, the risk management side, is to encourage the inspection because ultimately a problem's going to come up if it's going to come up. The seller has no obligation, though, in that instance. And I've seen sellers push back and decline it. So that's the best thing I can say is it's a situation where risk management favors allowing it to occur, but it's up to the seller. Sir? Yes, sir.
If we represent the seller and we have a pre-sale inspection,
Yes.
those inspections require disclosure by our seller.
Yes.
So we have to get a hold of those and disclose them to anybody else.
Yes. Yes. If a seller has done listing property inspection, pest control, whatever, that does need to be disclosed. Same goes with any plans, permits, all the stuff that relates to the property. Oh, is it a buyer's provided? Yeah, you have. Once the seller comes into possession of the buyer's property inspection, and let's say there have been multiple buyers because each time the escrow didn't close, all that has to be disclosed. Yeah. All the. Pardon me?
What are your requirements to obtain those? We're looking at pretty short times here. We can have
Yeah.
a period of time
Yeah.
to take offers. Somebody run, or three people run
Yeah.
pre-sale inspections.
Yeah.
What are our obligations to force those reports out?
Yeah, tough. The timing thing is really tough. My suggestion, and again, I defer to Zephyr management ultimately, but is to put something in writing to your seller early on, saying, please forward me all buyer 1, 2, and 3 that have fallen out of contract, all their property inspection information. If you have it, you've got to produce it. If another agency, if your seller doesn't have it and another brokerage has it, there's nothing you can do about that, right? Am I answering your question?
Okay, but we should advise the other people bidding that someone else has done a pre-sale inspection.
I think he's referring to buyers doing a pre-sale inspection. So
Right.
If you're on the listing side and you're marketing for 2 weeks and you find out over the last 3 days that 3 different buyers have done pre-inspections.
Yeah, you have to have possession of. You don't have to produce something you don't have possession of. So if you don't have possession of the buyers, you don't have an obligation to reach out to those buyers. It's something you have possession of, yeah, ultimately. If buyers are in contract, different story. When a buyer's in contract with you, they normally are going to tell you why they're pulling the plug in some manner. Normally, you're going to get a copy of those inspection reports. Thank you for the clarification. I apologize. Sorry I didn't pick up on that. There's another question? Yes, sir.
Yeah, in that similar scenario, because the agent is Zephyr Real Estate, you've got 5 offers, 3 are Zephyr agents.
Yeah.
Those 3 agents, buyers have done pre-inspections, is the obligation for the company.
Boy, I'll tell you, Dual agencies, when you have multiple representation, you have a tricky, as a broker, fiduciary obligation. Generally, I got to say, I would tend to err on the side of inquiring and producing. Because if a claim were to come in at some point in time and it was shown that a company, and I'm not talking about dual agency from the standpoint of seller-buyer, I'm talking about multiple buyer representation. And you had a claim come in and it was shown that pre-offer disclosures, pre-offer inspections rather, were in the possession of the broker. And they had material information in them, and that was not provided to, let's say, the fourth buyer who was successful, the like. I think that would be a very difficult one to defend. I think that would be a tough one. So I have to err on the side of saying it does need to be produced, yeah, without taking a stand on it. Let me mention one more thing about no contingency offers. There is a practice by some folks representing the listing party of countering back to a no contingency, which I'm sure you've observed, and giving the buyer a brief period of time to undertake property inspections. And that's a risk management play. I mean, I can easily argue for it. For a seller, you got a hot market, give them 5 days to look, or 7 days to look, bring in a contractor, et cetera, if they come in no contingency and you know they haven't done a pre-offer investigation of the property. So I just throw that out there and defer to Zephyr management in terms of how it wants to proceed. But I've seen that tool used. Again, these are all just risk management devices that anticipate someday what goes up is going to at least level off. And when it levels off, folks are going to be less happy than they are today. Okay. All right, so this one's kind of a straightforward one, but it comes up fairly regularly. Accuracy in the MLS, accuracy in flyers. I got to tell you, for whatever reason, I would say 70 to 80% of the lawyers who bring claims do not regularly handle residential real estate matters. They really are generalists, and they're somebody's uncle or brother, or you know, they are at a big firm and they've done commercial real estate litigation. They just don't know this area of the law at all. So what do? They start looking in a file, and it seems always to be the case. They grab the flyer or the MLS information, and they scrutinize it, and it's all about accuracy. There is a civil code section in California that does require you to base your representations, as you probably all know, in the MLS upon a reasonable basis in information, a reasonable basis. So lawyers get excited about a statute, you know, and there's the standard, and did you have a reasonable basis? I'm going to jump to the third point because that really pertains to this accuracy point. That was a lawsuit right there. You're looking at a lawsuit, the second component. All units legal. It's a property here in town. It was a Victorian, and it said all units legal. What they really meant was that 3 of the units were basically had work done per permit, and a top unit in the old attic was an illegal in-law. Okay, so what happens? It's kind of contradictory, but put aside the top unit, okay, because there was some information that the buyer received that put them on notice the top unit was not legal. So we had that for the defense. But it was a second component, the all done with permit. Well, guess what happens? The buyer didn't like the deal they got. Market had changed. This is a .com property. And so they start investigating, and they find out, well, that representation wasn't entirely correct. When you said all units were legal, okay, you thought you were right, but you actually turned out to be wrong with some very minor stuff. I mean, because .com was like today, crazy, you couldn't get contractors to come in and do work. For example, some of the electrical work, I know electrical is really, really important, but this stuff was in the kitchen. It was like with an island in the kitchen. It was extreme. It was stuff along the lines of installation of the garbage disposal for the little mini sink in the island type stuff. It was fairly minor, but it was illegal. So what did you have? All units weren't legal. What does that set up? It sets up a right to rescind and get your money back. That's what people do when a market really changes. They want their money back. Who's got the money? Who's got the money? Seller doesn't have the money. They've probably put it in their house, or they're living someplace else and you're chasing them, okay? So who's got the money? The brokers have the money. And that's who they come after. And then they get into these long, convoluted arguments about how we must have known, or you were reckless in disregarding information in order to try to get to us for rescission, which we didn't get the purchase price. What makes it fair that a broker would have to pay it? I hate to tell you, in California, there isn't. 1970s case that says when a broker acts recklessly, maliciously, intentionally, and nobody else can pay, they're the bank account. That's the short story of that case, and that's where the plaintiff's lawyers ultimately go when they get desperate. On withdrawal or cancellation, this is kind of a separate issue. More an issue to deal with that I've heard come up to deal with your sellers. Properties, let's say that you've listed something and it's been on the market and then the seller just insisted on a price that you knew you couldn't, you just knew it was too high. And so the seller wants to withdraw it, okay? When you do a withdrawal, be very, very cautious that your seller understands your listing agreement is still in effect. You've done a lot of work. Let's say you've got 90 to 120 days and you're in day 60 and the seller wants to withdraw and then resubmit in a week or two. Sellers sometimes get confused that withdrawing the listing from the MLS is the same thing as canceling the listing agreement. I know that sounds stupid, but that's sometimes what happens. And so just be cautious. Just tell your seller, I'm withdrawing it, and keep a good record and make sure they've got a copy of the listing agreement as they should have right at the outset. And that document has a specific deadline, of course, which is required by state law. So I mentioned that one just because it's come up, and as board counsel, I hear about some of these things. Sources of risk contingencies. Okay, so these ones are pretty straight up. Here you've got a buyer. They're in contract. They have a property inspection contingency, but they want to remove it subject to, they've done an inspection, and they want to remove it subject to the seller undertaking some work or paying for a credit. I'll ask the audience, is that an effective removal of a contingency? Anybody want to venture a response? No? Well, it's not. All you've done is replaced a condition with a condition, because we all know subject to is conditional language. So what happens in this instance is, in a hot market, the seller's already going, what did I even do a contingency deal for? And now their response is, okay, buyer, here's your grace period notice. You didn't remove the contingency on time. I'm not prepared to do that. This second one was a claim, not this company, of course. This one is just in this, we are moving so much faster than we moved 20 years ago. I don't have to tell anybody in this room that. I mean, right, you get in your car and your emails are going off and your texts may be going off. We know you're not supposed to look at that stuff while you're driving, and you're getting phone calls, on and on and on and on and on. And there is a tendency to not carefully stop, document, confirm, document, and then act. Right? It's almost like fighter pilots. They have this mantra about they target, I don't remember what it is, but they basically, kind of attention and focus, and then they acquire the target and they shoot, right? So when you are working fast with emails and with texts and so forth, be very, very cautious that you slow yourself down when you get to something as important as removing contingencies. I think documenting the authority to remove is just critical. We have had cases where buyers indicated that it was okay, and they throw in something at the last second in a call when you're in your car, along the lines of, yeah, we can do that, but I'm going to check with my wife. And then the agent just hears, we can do that part, and pushes the button, because it's so easy to push the button on the email. Removal goes over, and then the call comes in an hour or so later. Oh, no, we don't want to do it. Well, now what do? You're stuck. You're stuck. The SFAR contract has been written, and this was debated at standard forums, written to allow for delivery by email. So you deliver it, the minute it goes over to the other agent. The other agent is an agent. They stand in the same shoes as their principal. So now the seller knows that information instantaneously. There is no company favors, there's no courtesies. They can't do it. It's a breach of fiduciary duty. You've now removed a condition. So authority, I just recommend that. Tara?
How would you document that authority? I think you said document the authority
Yeah.
to remove.
Yeah. Email?
Email.
Yeah, I would just do an email. I think an email. I wouldn't do a text for the reasons stated. I would just do it quickly. But let me mention on documentation, in my experience, if you have it in writing, even as a note to your calendar, to the file, I hate to say, notepad. I hate to say Post-its, because I've gotten Post-it files where it's all Post-it notes. I strongly recommend against that. If anybody who's retrieved a file that's been in storage for 3 years with Post-its knows exactly what I'm talking about. They all fall off. They completely fall off because the stuff dries out. But I would recommend that you put it somewhere. We've had good experience with transaction logs, really good experience. You don't have to have an email. I personally think in this day and age, everybody expects that. So you're on the phone, in the car in my example, and you get back to your office and you say, client, I'm going to be, it's 10:30 now, thanks for the call. I'm planning on removing the contingency as we discussed per your request at about 11. Give yourself some time so it's not instantaneous. Please let me know if you have any questions. Boom, you're done. But you can just put it in your transaction log. You just get back to your office, jot it down in your transaction log, spoke to client said remove contingency, you send it out. Now you have a record that you can rely upon. Now, I like emails better because in a little time gap, half hour, 45 minutes, an hour, because now I've got solid proof. They have to respond to that. Whereas with my transaction log, it's personal to me, right? So it's not quite as good a defensive tool on things like authorization. I'll tell you where it's, though, I think an almost equally good defensive tool, and that's with things you discuss with your client about disclosures. When you put down, I was on the property with the property inspector and the client, we talked about the evidence of some water staining in the attic, and it looked like a little dry rot, and the insulation was deteriorating, and you've got that in your transaction log, that's just priceless. And for those who don't go to that level of detail or haven't in the past, don't live in fear. I'll tell you, the main thing I've found that's helpful is at least being able to reconstruct, based on a calendar, what you did in the transaction. Because if all you have to work with, given all the transactions you work on for every year, and to go back in time and only work with just the transaction file itself, the offers, the counter offers and so forth, real difficult to construct what you did. But if you have a calendar that at least shows what you did, where you were, it's amazing to me when people are under the stress of a claim what they can remember. And generally, I've been doing this a long time, I've only encountered, I want to say, maybe a half dozen bad apples in my entire career. I'm not Pollyanna about this. I'm not, it's not naivete. I think this town washes out the bad apples. I don't think they last too long. There's been some, but I haven't encountered that many. And that's not to say they're not out there. But the point is, the vast majority of agents are diligent, honest people. If you help them, if you help yourself to be able to recollect what occurred, it comes through when you are facing a claim. Whether it's a claim that goes all the way to a lawsuit, whether it's a claim that's got you sitting in the manager's office on the phone with a client, with a buyer or seller, or in a face-to-face, that mark of professionalism, being able to say what we did when we did it, shows that you viewed the transaction as important, and it helps you recall things. So that's where I'd go with that. Yes, ma'am.
Back to the subject too, I wasn't clear.
Subject to? If you use the terminology, if you say, for example, when you remove a contingency, and you say all property inspection contingencies removed, subject to seller providing buyer a credit of $15,000 for roof work, okay? By doing that, you have removed all contingencies and you've created a new contingency.
Right, is anything wrong with that?
It's legal, but the seller, who may have expected all contingencies to be removed by a specific date within 10 days or 5 days after entering the contract, now can send you immediately, your buyer, immediately, a grace period notice saying remove it immediately.
So
Then if they don't, because you're not, your obligation as a buyer is to conduct if you're in a property inspection, is to conduct your due diligence inspection within whatever that period of time is, 10 days, let's say, okay? If in that 10-day period, on the 10th day, you give a notice that says to the seller, I'm removing everything subject to a new condition, you haven't fulfilled your obligation. Because you
need to give them, so is the strategy, because if
Yeah.
you're on a $10,000 roof problem
Yeah.
that they didn't disclose, but
Yeah.
you have a roof inspection.
Yeah.
So are you saying that we should do that before?
Yes.
A couple days before, not
Yes.
the day of?
Yes.
So then there's room for time for negotiation.
Exactly. Did everybody hear that? So yeah, I think that's the practice of a lot of folks. Sure. If you're in a transaction with a buyer with a property inspection right, let's say a 10-day right, and you discover through property inspections that, for example, the roof needs $15,000 worth of work, right? If you wait until the end and do a subject to, you're going to put your buyer in jeopardy because the seller may respond to that subject to and just say, here's your grace period, you're out of contract. You had your 10 days, I didn't agree to this, you're out of contract. And the comment made, which I completely agree with, is the best thing to do when you discover the problem is to promptly negotiate for the credit while you're within your contingency period. And just send over and say, my buyer would like a credit of $15,000, and you negotiate it before you get to the point of removal, and that's definitely the way to do it. Yeah, thanks for the clarification. All right, so next. Oh, sir, I'm sorry.
Could you comment on that standard form, the contingency removal one, just in terms of how diligently should, if you're on the buy-in side and the seller, or the seller side, be following that form along the way of progress of the transaction?
Well, I'm not sure I could answer that one. I'm not sure if I fully understand your question. There are several contingency, are you talking about the contingency checklist, or are you talking about the contingency removal? The checklist? Yeah, I mean, checklists are there to be, they're tools to help you. I mean, agents have a duty, all agents, both for the buyer and the seller, have a duty of reasonable diligence, right? You have to be diligent for your principal. So checklists are there to help you to be reasonably diligent. I think following them, I don't know how to answer the question beyond that. I think if you have a 10-day contingency, showing that you've been diligent, reminding your buyer they need to make their loan application if it's a loan contingency, for example, helping your buyer get their inspectors, helping them get the inspectors on site, that sort of thing. I think that's going to all be independent of that checklist. I think the checklist is just there to remind you what the deadlines are. Am I missing your question, or is that?
No, I guess at some point you should have that checklist completely signed off on.
Yeah, ideally. Yeah, I agree. Okay, so this is, yes, sir.
And what Michael was saying, though, if you use that form,
Yeah.
you say we're going to remove this property inspection contingency, you send it to your client, they sign it, you send it to the other agent. It seems to me that it eliminates the need to write that email.
It would. That's true.
Seems to me.
Yeah, that's true. Yeah, I would agree. Yeah. All right. This one's probably self-evident. Misunderstandings. That's the main thing. Out of town. Here's the problem with out-of-town agents, whether they're from the Peninsula or from the East Bay or anywhere else in the state of California. If they're from the Peninsula, they work with both PRDS forms and with CAR forms. If they're from anywhere else in the state of California, they work primarily with CAR forms. Our forms are different. That's the reality. And we have major differences in the contingency sections that out-of-town agents don't understand and appreciate. But there's a full nother layer of misunderstanding, and that has to do with local practices, and I should have added local property types. They just don't have, for example, somebody who practices, and it's no offense to people in the Inland Valley, but in the Inland Valley and comes here and is doing a TIC transaction, they're not gonna have a clue, right? And what's gonna happen is they're gonna lean on anyone who does have a clue. So if they are on the other side of a transaction because just so happens that their seller is their aunt and she's getting to an age where she wants to sell, in my example, and you're on the other side of that, just be forewarned that you may find yourself being asked to do all sorts of things. Can you help me with forms? What does this mean? The more you get sucked into when you are on the other side of the transaction, being friendly and collaborative with an agent who's from out of town, and I'm not saying we don't want to help our neighbors, but I've got a solution for them, I'll tell you in a second, the more your risk goes up. Because what they will say if there's a claim is they were relying upon you. In fact, I hate to tell you this, but their principal is going to hear all about you. It'll be great, right, during the transaction. You're going to be, oh, they're so helpful, and they've been providing me with all this information forms. They told me we should do this and we should do that. Guess what the seller starts thinking? You're my agent. Okay, you're helping me. You're representing my interests. And I know it sounds, we got all these forms, dual agency, agency disclosure, blah, 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 but that's just a risk that happens. The solution for out-of-town agents is essentially refer the matter to somebody local or associate with somebody local who knows what they're doing and share the commission. They don't want to do it. I get that. But that's the solution. And I don't have another one. And by the way, this reverses course if you're going outside of your own locale. I know in this market it may not happen quite as much, but when you go outside of your own locale, you're held to local standards. So if you go up to SAC, if you've spent your entire life working with the SFAR form set, and for the first time go up to Sacramento, and you're selling up there, you're going to have to get a quick indoctrination in terms of the CAR form set, which it can be figured out, but you're going to have to figure it all out in advance. And what are the local issues? Are you going to have access to their local disclosure? I got to tell you, almost everybody has the equivalent of the general information statement in one shape or form right now. PRDS land has one. There's one up in Marin. I know there's one in the East Bay, and I know from talking with a risk manager yesterday at Standard Forms, one's being developed for Sacramento. Are you going to have access to that? Because if you don't, and that's not provided, I got to tell you, there'll be an expert somewhere if there's a claim saying your standard of care was to deliver that sort of document. Just like if somebody comes into town and they don't provide their clients with the general information statement, and there's something in there. I know things like Encyclopedia Britannica now are going to try to make it more succinct, but if there's something in there that could have helped them, they're going to blame you, the out-of-town agent, for not knowing about it. So I just mentioned that because it's happening. Internet referral companies, I'm not going to spend much time on, but if you get an internet referral, an out-of-state referral company, just be forewarned. It's like buying a book on Amazon. They have a user agreement. It's a click agreement. If you read their agreement, you're going to see they're getting you to indemnify them, right? You're indemnifying them for all this lawyer mumbo jumbo, all these claims that could occur. They're going to tell you what your commission rules are, even though they're not, a member of the MLS. They're going to tell you if there's a dispute, you're going to go arbitrate it in Tennessee, okay? So I just want to warn you about that kind of a risk. Okay, pocket listings, not going to spend a lot of time on this. I mean, here's the bottom line with pocket listings. It's kind of like with lawyers. If you don't get your client to give you a retainer, you don't have a client. That's the reality. With pocket listings, you have a client, but you don't have a client because they do not have to pay you a commission under state law unless they ultimately sign something in writing that says they will agree to pay you something in state law. And state law has a very important notice that's there in bold print that says commissions are negotiable. So I understand pocket listings are tempting. I generally don't recommend them. I think they lead to disputes. And the main one is over what the commission was going to be. What's the percentage going to be? It's almost always, oh, I thought it was going to be a little lower, or I thought we had to pay the buyer, 3%, but you're going to take 1.5%. It's all this kind of stuff. So I discourage them. Okay, work by seller. I just mentioned this briefly. This is a recurrent risk management issue we've had come up. A lot of it has to do with after close of escrow, but here's what happens. The seller has done a bunch of work on their own. They have been the Home Depot person. It may look great, right? But it falls apart after the deal closes. It turns out to be poorly done. That one is a risk. The other one, and that should be disclosed, the seller did the work, should be disclosed. After close of escrow, holdbacks and releases go together. I strongly recommend against doing holdbacks unless you refer the parties to attorneys. It's not an employment act for lawyers. It's not the reason I do it. It's a recurrent problem, and here's what happens. If there's a dispute, and there's almost always a dispute, somebody doesn't like the way things happen. $25,000 is parked, in a holdback, for example. It's supposed to be for some fix-it work. Some of that fix-it work is going to be done by the seller. It doesn't get done on time. Buyer's unhappy. Buyer then hires a contractor. It costs $35,000 to get the work done. Buyer wants 10 grand. Seller thinks that was excessive. It was supposed to be done by seller. You got a dispute happening, two people unhappy. They scrutinize what you wrote up if you're the agent doing a holdback agreement, and they hold you to the standard of a lawyer because they say there should have been some provisions in here that made it very plain that it was only to be work done by seller and that there would be no work done by a contractor without the parties' mutual agreement. It doesn't plainly state that, even if that was the intent. Or another one is, there should have been a release in here. And worse yet, there is a release in here, because that really is practicing law, and you've had the buyer waive all rights for all claims forever against the seller for some piddly $5,000 worth of work. And guess what? 3 years later, it turns out there's a foundation problem that should have been disclosed, and there's $65,000 worth of work that needs to be done. Just forewarned, I would strongly recommend that you refer that out, holdbacks and releases. Okay, so this is getting into CIDs, which are common interest developments. That embraces condos and co-ops, all right, and TICs. And I group the next few slides under plain view because here's some recurrent problems that happen with TICs. The first one usually is with the larger TIC projects, the towers, the South of Market towers, for example. You are regularly working in a building representing buyers and sellers. Okay, it's become a property you've gotten to know well. And there are flyers posted or left in the common areas that tell you there are all sorts of meetings going on with litigation professionals. You've got to disclose that. Once you know something, you have to tell your buyers, you have to remind your seller, and you have to make sure it's in your portion of the TDS that you've observed this information. Buyer's urge to investigate. You don't know the status, but buyer's urge to investigate. The second one's come up. We've seen how fast some of these cranes have gone up in the South of Market area, right? There were fences up for years with permit notices, some expired, some new. What happens is one tower's up, 40 stories or more, it's great. You've sold to some buyers, they've got these great East Bay views or whatever, and nobody's really paid attention to the vacant lot immediately across the street to the east, which ultimately gets a crane, and the crane ultimately gets a building. And away goes the view, away goes the light and air. And the blame is, you didn't tell me you knew about that, so I warned you. This one, last one seems almost ridiculous, but I've had it happen. Scaffolds are up on buildings, you're aware of it, you know there was work ongoing, you know they weren't just painting, you could see people up there doing some kind of work around the windows, putting in new windows, and it's not disclosed to a buyer, and it turns out that was some very serious work that was undertaken and not disclosed in any of the minutes of the property. Okay, so older, smaller properties and noise transmission. This one is, I mean, if there's something that's like a poster child for recurrent themes, it's this one. Noise transmission just seems to come up. It's like spinning the wheel. I'm going to get a claim for noise transmission about once every 2 years. I can almost guarantee it. And we've done a lot. We've done about as much as we can do with our standard form advisories. It really comes down to when you, the agent, go into a property, keeping your ears open and smelling the property and so forth, and letting people know what you observe. That's the best you can do. Here's a couple of comments. On the older, smaller properties, particularly the old Victorians, when you walk in the door, and it's a condo property, it's a 4-unit condo or a 3-unit condo. You walk in the door, and there are the stairs. The carpet is this like dark color. You can't tell if it was red at one point in time or gold, right? And you're looking around, and things seem kind of warped. It almost looks like they may not be water staining, but the entry area looks like there's some warping or the like. And you go upstairs and you go, oh, well, I read some of these rules on disclosures, and I'm only supposed to disclose for condos the unit, the information about the unit. I don't have to get into this common area stuff and just blithely go on by. And on top of that, you smell as you walk in this kind of musty smell. You're just basically, you're being put in a plain view situation where you have a duty to disclose to your buyer who, let's face it, there are buyers. I've just had a call from a fellow in Chicago. He bought a property. Third time he was skunked, lives in Chicago, bought a property sight unseen for over $1 million. Just blew me away. That's what's happening in this market. Sight unseen, just did it on paper. You have a duty to basically disclose what you observe in your TDS. And what you observe isn't just with your eyes. You gotta, in the mold cases we had about 7 or 10 years ago, if you smell something, disclose it. Noise transmission, same thing. Here's something that's happened real recently, and I don't know that we've got a great solution for it, and it really falls more on the sellers. TICs, where anybody familiar with construction knows that older properties, wood structure properties, transmit sound. Wood transmits sound. That is it. There's a sound engineer, if you ever have to be around one, in a claim, like I have several times. They're great, engineers are great, but they're very expensive, and they're going to tell you there is really only so much they can do. They can put padding, they can put insulation in a wood frame building. At the end of the day, they cannot stop sound transmission because the sound waves travel through the wood that vibrates, right? Wood instruments. So it's a real problem, and there's just not a way to get around it. I think the best you can do is just keep your ears open. Now, here's the thing that happened with a TIC. A developer did some wonderful work. TIC is in a nice part of town, almost all parts of town now. The Mission's nice, but it's all luxury features, and all this luxury stuff is in the marketing material that the developer seller sold before they brought it to you. Either on the listing side or the selling side. And so you're handing off all this stuff to your client, to your buyer clients, or you're the listing agent, you're handing off this stuff to the agents on the other side of the transaction disclosure package, and it speaks to luxury. And guess what? If somebody buys a luxury property, they expect what? No sound transmission, because you wouldn't expect that at the Four Seasons, would you, right? That's exactly what you're going to hear from folks. If there's one thing I've noticed, no matter what market we're in, noise transmission drives people nuts. It drives them nuts, and it's almost impossible to solve the problem once they've experienced it. It's like the water dripping that wakes you up at night, or the mosquito, if you've ever been camping, that just seems buzzing in your ear and won't go away. Once people have a noise issue, they just never let it go. I've seen that with the dog running every day on the hardwood floor to the front in the upper unit, and it's driving me nuts. I've seen it in worse examples with a home entertainment downstairs in the basement and the two walls abut, and somebody's got their home entertainment center, their theater on the other side, and they're blasting away at midnight. And then the adjacent bedrooms, right? That's another one. So it's a real tough one. So just keep your ears open and do your best. And on that one with the luxury thing, I think it's a matter of being cautious, and if you're on the buyer side, strongly recommending an investigation of these sorts of issues. The general information statement does have a paragraph in it that we point to when a claim comes in that says, look into these things if it's important to you. That's about the best I can say. Okay, back to condos primarily, and this is more condo towers. I'll go through this quickly, but this one is a recurrent theme as well, and I get it. It's been going on since I've been practicing, and I totally get it. It's a great marketing model to go be the resident agent in a condo building, 30, 40, 50 or more unit condo building, and become, the queen or the king of that building, right? It's great. Everybody's going to respect you. You're going to have more business. They'll all be kind of captive customers, and that has worked for people over the years, and I understand it from a marketing standpoint. The problem is everything you learn, particularly if you own a unit, now has to be disclosed. So it's not 1 year of minutes anymore, folks. It's all the minutes of the HOA you ever received while you're an owner. 5 years, 7 years, 10 years? What if there's something in there that somebody cares about that you forgot to disclose? You're going to be responsible for it. I strongly recommend, don't go on boards of directors. You're a fiduciary at that point in time. You're a board fiduciary, and you're a fiduciary to your client. You've got two fiduciary hats, and they're mutually inconsistent hats. What you learn as a board of director may be information that is important to the other owners of the property. I got to tell you, I've heard this one in litigation. The HOA members don't want the agent, board member, to disclose information that's going to hurt the value of their unit. You're going to hurt the value of our unit. I've got to disclose this information to my buyer. No, you're going to hurt the value of all our units. You can't do that. Don't want to put yourself in that position. And Lord help you, if you join executive sessions with attorneys. That means you're in private conference on litigation matters with attorneys. You've just tripled down on this thing. You've got one fiduciary hat on to your buyer-seller, one for the board of directors in general. Now you've got one that links you up with a HOA's attorney, and good luck getting permission to disclose the information when you have to sell. So my recommendation is, if you're going to do any of these things, just do the first one. Strongly recommend against the rest, all right? Okay. This cuts across all property types. Be careful about identifying, maybe you have a company practice, I don't, but be careful about identifying yourself as a specialist or an expert. Lawyers love that. They just eat that one up if there's a claim. Oh, you're the expert of Noe Valley, are you? Oh, then you must know about this. Well, actually, I never heard about that. You must know about, they'll hang you on that. So be careful. I personally think safer language is like emphasis. I emphasize transactions, or I've resided, I've resided in a property for a number of years, so I'd be careful on that. Retreading management companies, this is again for condos. Condo management companies charge for the disclosure packages they put together, right? And they can be a couple $100, and who wants to pay that, right? So what some agents will do is they have done 2 or 3 transactions in a year in the same building, and they'll retread the stuff. And what happens when you retread? You take the risk that one of two things has happened. Either you screw up when you're copying and you don't include everything, or there's been a change, a new document's been put in there. And if something occurs and you've done the retreading, saving yourself, it's penny wise, dollar foolish. You spent some money, saved some money to get yourself into a more difficult situation. All right, we talked about prior transaction files. This is just an expansion on the point. Minutes, budgets, letters from HOA attorneys. I've had all those come up. Sign in for HOA meetings. You're a resident agent and you're signing in, or you're just a visitor and you're signing in to sit in on HOA meetings. If you can get in somehow, you're creating evidence that you were there. You better well remember everything you learned, particularly if there was any talk about a condo defect investigation. This one's tough. This cuts across into TIC land as well. Information on dedicated owner websites, Facebook pages, etc. What do you do when you learn that a 4-6 unit building has a dedicated Facebook page for owners, or a dedicated chat room or website and there is 6 or 7 years of history, I strongly recommend you treat it like a public record and not start looking at it. Because once you do, just like a public record, you're going to be obligated to deliver all of that information to the extent it's material. And materiality is in the eye of the beholder, and the risk managers I've been around over the years all have a similar rule of thumb on what's material or important. If you're asking me the question, it probably is. And that's what you're going to hear from lawyers over time and from experts. So the best advice I can give you, use a disk. Just make sure, ask your seller to have everything put to a disk, hand off the disk to the buyer and say, suggest you take a look and see if there's anything in there that's important to you. And by the way, we changed the San Francisco Association changed its supplemental TDS to add specific questions that now require the seller to identify such websites and ask for the permission so that a prospective buyer can take a look and view it for themselves. Smoking and rental limitations in condos, I'm not going to go into that one, but that one is primarily where you have like a 6-month rental. You have to rent for no less than 6 months or no less for a year, et cetera. People don't know about that. They want to do short term. What do you do if you want to put, Airbnb? All these things are coming up. Smoking, this one is there are no smoking properties. People don't get that disclosure. They don't read the CC&Rs. You have to be real careful if you're representing a buyer and you've got a CC&R package to go through it and see if there are other sorts of restrictions. I know it's a legal document, but if it's in there, some expert's going to say you should have found out about it. Nuisance neighbors, this occurs both with condos, TICs, and with single-family homes. This one is, the classic scenario is you're in an open house, it's your open house, you're the listing agent, and a neighbor is taking a look-see, lovely house, oh, blah, blah, and you can hear them talking to other agents or to prospective buyers. Yeah, it's great except for that, property across the street with those people that have folks showing up at all hours and they play basketball at 1:30 in the morning and I don't know what they're doing over there. And you hear it and you don't disclose it. I've had a similar example, not with nuisance neighbors, but with open houses where a listing agent overheard, she didn't know, but she overheard more experienced agents in her locale saying things like, yeah, they did a great job on that downstairs rec room, but I don't think they got permits to you. And they go, no, I don't think they did because I can recall when that property was in the market last time. And these sorts of things you have to report with. Here's what you do, because you don't want to ever, if you're going to report a nuisance neighbor, right, disclose, you don't want to risk being accused of slander or the like. So what you do, libel or slander, what you do is you say, you identify the source. I overheard appeared to be a neighbor at the open house in my example, state that across the street there was a neighbor who played midnight basketball. Buyer urged, unverified, I don't know if that's true or not, unverified, buyer urged to investigate. That's the mantra. It has 3 simple elements. Identify the source, say unverified, if that's true, and the buyer's urged to investigate. There's a case right on point that says if you do that, you get a free pass. It's on the buyer now. Yes, sir?
What do you do if some of the neighbors say, oh my God, I'm so glad your seller is moving because we don't like them?
Yeah. Everybody hear that one? I've had that one come up, particularly in condo properties. We're so glad we don't like them. We have different specific issues about them. You've got to be careful about that one in terms of a disclosure. Because here's your problem. It's not the seller who's the problem. It's are the neighbors the problem. I mean, anybody who's done with TICs, we were at the board yesterday for Standard Forms, and we were talking about revisions to the TIC disclosure and agreement. And there's going to be a revision that deals with compatibility. We're struggling. What's the right word for that? Is it, it's kind of like the emotional temperature of the other TIC owners? No, that's not quite right. Compatibility. And so that's the question. I think it's got to be disclosed. I think you just flat out say that a neighbor at the property informed me that they were happy the seller was moving. They did not specify a reason. I have not investigated it. Buyer's urged to investigate. And you leave it at that. I would just stick with that simple formula. And the buyer's going to say to you, if they're your client, well, geez, can you make some phone calls? Can you check up on that? Obviously, my recommendations can be you not do that and advise the buyer to. But that's really a tough situation, the only way we can handle it. You have to disclose it. If it turns out the buyer comes in, strongly recommend you disclose it. The buyer comes in and they find out that it is indeed difficult neighbors, incompatible neighbors, they're going to blame you for not providing that information. Okay? Sir, ma'am.
How about if a seller says the neighbor next door is
Yeah.
She lives by tree, whatever.
Yeah.
So,
Got to be disclosed.
say it nicely.
Yeah, I don't think you, I think, you know, for those who remember the Dating Myself, the old Dragnet show, the mantra really is just the facts. I would just stick with the facts. Say, neighbor inform me that, or seller inform me that neighbor has been difficult, or whatever language the seller used. Try to avoid stuff that's a little too colorful. Try to translate it, but not too much, just factual. Really want to ask the seller, if the seller is reporting it, what is it they've done that's been difficult or crazy? And put the facts down. I actually had a case here in town where a lady who was a retired dental assistant, I'm not sure if that correlated to this, but she had all these surveillance cameras on her property, and she didn't like the sellers, a young couple with 2 kids, and did things like left chicken parts in the driveway, and it was really weird. And so there was a claim that came in, and that was not disclosed at all, which was a problem. But I think if you said crazy, you would be, you know, you're just not really providing information. I think the proper disclosure would be neighbor maintains security cameras that appear to point at our property, and on occasion has left chicken parts or garbage on the drive, and just be flat out, and say unverified, because you as the agent, you don't know. This is hearsay to you. You're being told this by your seller, or as I said, or an open house neighbor. It's unverified by you, and then you just advise the buyer to investigate. So that's the best we can do with it. Square footage representations, we keep having these things come up. I just had one in the East Bay, nice house. What happened was the agent passed along the information from a prior appraisal report. Okay, I've just told you I think that's generally a good idea, but what they didn't do is pass it along with something that had that same formula. The source of the information is an appraisal report that the seller provided from when they bought the property. Unverified, buyer urged to investigate. They just passed along that one sheet that shows us, the floor plan and the square footage. You've probably all seen those things. Turned out the appraiser was wrong. The appraiser was wrong by about 400 square feet, and it really mattered to the buyer, and they wanted to rescind, and we got into a deposit dispute, and I had the seller, and the buyer had to give up 50% of their deposit. So somebody's really unhappy. And the worst part about it is for the agents, and I hope it doesn't go anywhere, and it has nothing to do with this company, it's an East Bay related thing, is that there were these texts that went back and forth. So the seller's agent actually, at the seller side, the listing side, if you will, had done a good job saying you should look into some things, and the buyer's agent was acknowledging that there could be this delta, this differential, and it didn't get disclosed to their buyer, and it's just a shame. But those things happen, so be very careful with square footage. It's reoccurring. And here's why is it important in a hot market? It's important in a hot market because I have seen buyer, particularly investor, speculator types, come in the door and say, oh, I know what the value of the property is, Alex. I don't need comparable sales. I don't need that. I use square footage numbers and trend lines and statistical analysis. And I'm looking at it, I'm like, you are crazy, because real property is unique. Each property, each house is unique. It has its own features. Could be side-by-side homes, right, with great dirt, lousy interiors, and square footage doesn't pick that up. But square footage can be very important to buyers, and so be wary of making those sorts of representations. Briefly, CC&Rs, proof of delivery, this comes up in condos. Here's a corollary with TICs, making sure TIC agreements, all the documents are provided. Just standard stuff, right? Get proof. But what happens when it's like the general information statement, and it's 50 pages, or the CC&Rs are 50 pages, and all you have is the first page initialed? Make sure make sure your practice is simple. My practice is always to give the buyer the entire document. I only save a copy of the first page. Make sure you can say that straight under oath, no question, or I recommend you keep the entire copy to your file. Designated parking and historic use of common areas. Okay, this one is about primarily older TICs and older condos, the 3 to 4 unit condos. What's happening sometimes is down in the storage area, very informal. There's no chicken wire storage boxes or whatever. Instead, they've just like painted on the floor, or worse yet, I've seen like that orange safety tape. I thought that was a clever one. And it was all deteriorated. And what happens over time when you don't have partitions is that the boxes start getting pushed over to the other side. And I've actually had claims, went out by the beach, where a retired physician was arguing with a retired teacher about having a right to keep storing their boxes that had been there for over 6 years in about a 3-foot by 6 or 7 foot rectangle on what was by the designated parking and historic, it was designated storage, the other neighbors. And so what was the dispute about? Prescriptive easement rights. Yeah, that's what we originally agreed to, but I've been there over 5 years. I've been doing this for 5 years. You didn't stop me. I get to keep doing it. Same goes with parking. When people flip parking because they bought a newer car and it's bigger, and you mind if I flip spaces because you have a little sports car, and then that goes on and on and on, and then they get a dispute later. Yes, ma'am?
In that case, who wins if they have to store it?
There's a right of prescriptive easement for use of over 5 years. Continuous and hostile, continuous, open, notorious, and hostile. And those words boil down to objective information, objective evidence. The eyes see that an object is in my property space, and I did not permit it. I did not in any manner permit it. So if there's evidence that we had a deal, then there was permission, then that cuts off the 5 years. If there's no evidence of a deal, that's a risk. Incomplete formation documents, inconsistent maps. Okay, so this one is mostly about the small condos, the 2-unit condos, where they've got CC&Rs, right? You have to, subdivision map, CC&Rs, but they don't have any kind of bylaws. They never incorporated, right? Why are we gonna have a corporation and pay $800 a year or $900 a year to the Secretary of State of California for having a corporation? And it goes on and on. So the main takeaway on that one is it's okay if folks want to have an informal association, but did they keep minutes? Do they have any kind of records to show the repair work? Do they have reserves at all if the roof goes bad? And this is the perennial problem with the smaller condo properties and the smaller TICs, all TICs really. It's do they have adequate reserves to fix problems? And do they have management in place to talk about problems? And is there some record keeping that I will be able to provide my buyers particularly that shows them they're not buying into some dysfunctional group that doesn't know how to do business with one another or has never come up, even though it's in the TIC agreement or the bylaws, they've never followed those rules. So that's a problem. Inconsistent subdivision maps. I don't think it's going to come up too often for y'all, but be wary with condo properties, particularly the smaller ones. The subdivision maps, if you get a copy of them with a prelim or you have the link where you can click and go look at them, there can be information in there in the descriptive areas. There are these little, usually in the corner, a box with these numbered paragraphs. There can be information there that can be very, very important. And we can all say, buyer, you could have looked at it too, but guess what? Who's going to get the blame, right, if there's a problem? And I had a case come up some years ago, FBI agent, wonderful gal, she did not get she knew there was a subdivision map. She did not get the information that in this little rectangle, her unit in a North Beach condo conversion from the 60s or 70s had affordable housing. It had a cap on it that turned out to be like a $200,000 cap. All the rest of the money she could not keep. It was really screwy. And that was not pleasant. The title company ended up paying for that, fortunately. All right, are we doing okay on time, Tara?
I think we gotta
Wrap it up? I'm sorry. Real quickly, let me just cover, I'm almost done. TICs, remember, TICs, it's a form of common ownership. It is not like a condo. If there's one takeaway today, TICs are not like a condo. They are not. It's a form of common ownership. You may as well be partners. They're not TIC units. They're actually TIC interests. When you look at the very top of the San Francisco Association of Realtors form of contract, that's spelled out. Greater than 4 interests. So now, greater than 4 physical units, physical apartments or whatever, that is going to take a DRE, or now Cal BRE proceeding. There should be some documentation on that. Recording TIC memos, that's being investigated right now. Historically, we've been of the view that shouldn't be done. There are folks in town who are doing that. If you see one, stay tuned. Agreement in place, standard. Vintage of the agreement, watch out for the older ones, right? If you're familiar with TICs, selling TICs, let your buyers know. That looks like a pretty old one.
At what year are they vintage?
I think anything over 7 or 8 years, Tara. Yeah, I think .com they got maybe a little bit, because .com's now 14 years ago, hard to believe. The pre-.com are really dangerous. The .com are better. I think anything really after about 2000, 2001 is usually pretty good. But keep in mind, these folks keep improving them. They improve them because of track record, of things they learn. I talked about reserves. Rent control tenants, I think you probably got enough on that. Just be wary of getting involved with the tenants when you're selling, when you're the listing agent. In any kind of discussions or negotiations, you're going to get sucked into a claim if there is one. Subpoenas or invitations to lawsuits. If you get a subpoena, tell your management. I strongly recommend it. Lawyers, there are no friendly lawyers, okay? If a lawyer calls you for your buyer, seller, client, they want information, they're not friendly, tell your manager, let your manager get involved in that process, because, even me. But keep in mind, what they often want is the file, and what happens is if you just turn over the transaction file, even though they represent your client, there may be information in there inadvertently that pertains to things that involve the other party. And frankly, sometimes there's things in the file that management may want to take a look at in advance and ask you some questions about, because there could be agent dialogue that is in emails that they just want to have a heads up on. Let's see, how's the other side going to view? Oh yeah, the other side always hates you. They always hate you. When you cooperate with a lawyer, so you're the buyer, you represent the buyer's lawyer calls you, they ask for cooperation, you provide it, you give them a statement, you give them a declaration. Guess who now hates you? The seller. And the seller has an attorney almost always. And they want you to now pay in some manner. And that usually means invitation to a lawsuit. So, I don't know if there's any time for questions. Probably picked them up on the fly. I can take them. Do we? Oh, you made me fly through it. Jeez. Any questions? Yes, sir.
What if you're representing a client for the first time and you look at the 3R, which you said is not very reliable,
Yeah.
and you notice that the permits that are on there are inconsistent, or you see serial permitting on there? Do you have fiduciary responsibility?
To identify it, yeah. So the question is, when you get a 3R that has inconsistent information, do you have a duty to your client as a fiduciary, to your buyer client primarily? Yes, you have a duty to point out the inconsistencies. Yeah, and so for example, let me tell you one I just observed is the issuance dates and the completion dates of permits did not match up. Several of the completion dates did not have the permit number reference, so you couldn't really be sure if the permit had been completed. So it could be an outstanding permit still, and there was insufficient description on what had been completed. So that one, the recommendation was to identify that for the buyer.
So at which point, since you're representing the seller, you did not recommend going to DBI, but at that point, would you ask for the records that they had at DBI?
I think I would ask my seller always for records of permits and plans to turn over to the buyer. I think you want to turn all that over.
If the seller doesn't have it,
Then I
recommend going to DBI?
No, I would not recommend going to DBI. I would recommend the seller. I'd point that out to my seller, say we're going to have to turn this over to the buyer. This could result in a whole bunch of questions. I'd recommend you considering, you can either do it yourself, or I'd recommend you engage a qualified contractor or architect to go pull those records for you. There are plenty of contractors in town who will do that for you, and they're not, it's not, they charge something, but it's not wildly expensive. All right. Well, thanks very much, everybody. I greatly appreciate it.